welcome to Uncivil Law for afternoon session. I hope all is well. First of all, I need to start right away by taking a shot because there was a PayPal donation that came in that I had missed at 11:24 a.m. I'm not sure if I was still streaming or not at 11:24 a.m. right now, but either way, I don't believe I drank for it. The super chat message said, "Grift harder, my friend. May I suggest lurking on a panelist as well? Not my stream, obviously." Well, we're going to do that. It's one of the reasons that I put it up in Streamlabs this time, because I apparently missed Nate the lawyer, who apparently was waiting backstage for 10 minutes for me, and I didn't notice him, and I abandoned Nate the lawyer, which makes me sad inside. I'm a bad streamer. Sorry, Nate. My bad. Anyways, for the previous PayPal donation, you know, we have to make sure that we got all that stuff. Great. All right. So let's go ahead and put Darryl Brooks on screen in all of Darryl Brooks glory. I know you're excited. I'm excited. How could you not be excited? It is everything we've always wanted it to be on every level. So yeah, good times. Yeah, what are we doing? We're doing an Evan Williams seasonal thing. It's very nice. Excuse me. Let's go ahead and put that on subscriber mode because it got a little cray last time. We always want my mods to be happy. Happy mods, happy stream or something. I don't know what the saying is exactly, but Mr. Brooks does not look happy. That is true. He looks very sad inside. I'm sorry he's sad. I hope he gets happier soon. Good timing.
All right, we are back on the record. It is 1:01 p.m. State versus Brooks. Appearances are as they were before. I would note I have instructed, and Mr. Brooks is present in this courtroom. Prior to the, I understand your objections noted. If you would like to go back to the other courtroom, sir, you may, but that is a choice that you would be making. I am not requiring you. I'm not forcing you at this time.
So you're not holding me in contempt?
Sir,
She's not held you in contempt at any point.
You or forcing you to go into the other courtroom. It is a new part of the day. I thought it appropriate to have you brought here. And only if you forfeit your right by conduct will I put you back in the other room.
So you don't address subject matter jurisdiction for the record, or are you going to state it on the record?
I'm declining to address that on the record for the reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record.
Your objection is noted.
Can I go back in the other courtroom? Because I'm not going to do this with you.
Okay, great.
Mr. Brooks, I do want to go over
We don't have
jury instructions.
I don't understand the jury instructions. I don't understand anything that's in these proceedings.
He said he wants to go. Send him over.
Participating in something that I don't understand.
That's your choice, sir.
May I please go back into the other courtroom?
You can, based upon your choice and your request, I'll make a finding that he's forfeiting his right to be present in
I didn't
this
forfeit
courtroom.
anything. I asked.
I understand you've
So I
asked,
didn't-
but
I
I
didn't
feel it's
forfeit
important to
anything.
also make a finding based upon your conduct.
Based upon what kind of me asking?
Are you willing to expressly waive that right on the record right now?
I'm not gonna expressively waive anything.
Are you willing to
I'm making
engage in a colloquy regarding your right to be present
I
and
do
a
not.
knowing and intelligent and voluntary waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a request to not be present in these proceedings.
And to be in the other courtroom?
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand.
Send him back.
I'm not
Send him
making
back.
a voluntary waivery of anything.
Are you willing to be, let me rephrase that. If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Well, given that he won't answer the questions directly, for now, he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor?
All right, let me start with the jury
You
instructions.
start
There's
with,
one I
you
would
start
like
with subject
to.
matter jurisdiction?
No, I've declined that already, sir. I'm not gonna address
Under
that
what
further.
law? Under what lawful law?
Sir, please do not interrupt me again
Here we go
with the
again.
topic of subject matter jurisdiction, or you run the risk of forfeiting your right to be present in this courtroom.
Then let me go in the other courtroom then.
Are you willing to engage in a discussion about that, sir? I need to make an appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Your
But it
rights
doesn't
are not
matter what we
unfettered,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me because I
seems to
don't
me
understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that right?
anything. Nope. I don't understand. Nope.
Then you're gonna stay here for now.
And under what lawful law? You can't force me to stay somewhere that I'm making a request not to. You can't make me understand.
Yes, you can. That's one of the nature of being in
You can't force
custody.
me to understand what I don't understand. You can't force that.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present in these matters without disrupting the courtroom, as you say that I do, and over talking you, as you state that I do. I'm making a request merely to not be present for these proceedings. Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that I'm not needed. I have never consented to anything that's going on here today. I haven't even been allowed to present any evidence, which is something that I stated weeks ago. Weeks. You already knew, Your Honor, that I wanted things to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
In your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom and throughout these proceedings, and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions this morning when this court went through or attempted to go through the colloquy with you regarding your right to testify and your right not to testify. And because of that, and based on the case law that I cited this morning, I made a finding that you forfeited your right to present further testimony and evidence through other witnesses, and then you forfeited your right to testify on your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but I'm just they weren't correct.
I understand you will
because
disagree
I
with
never
that.
consented to it and I never answered something.
I understand
and
you
I
did
just
not
stated
consent
the
to
reason
that.
why I didn't answer because I don't understand.
God!
You cannot force me to understand what you're asking.
No!
Sir, I could not even get through the advisement. You wouldn't even listen. You talked over me repeatedly.
Was that from the other courtroom or in here? Because I've been over there all morning.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right. So I've been over there all morning.
With an adequate audio and visual system connecting the two courtrooms.
Your
functional equivalent to your
equivalent is adequate, but to mine it's not. Seeing as how you always state Illinois versus Allen. You always state that. But it never refers to a fourth option that you refer to. It never
Mr.
refers
Brooks, I'm not
to
going to debate this with you. If you continue to bring up subject matter jurisdiction, Illinois
I
versus
didn't bring
Allen,
up subject
the
matter
decisions that I
jurisdiction.
made earlier,
I'm trying to figure out why I'm being
you
held
are
in contempt.
frustrating the purposes of this hearing
I'm trying to
right
figure out
now,
why I'm being held
which
in
is to
contempt.
finalize the
And
jury
then when
instruction and the verdict forms.
Your Honor, I'm merely trying to understand why when you hold me in contempt.
I never held you in contempt, sir.
You attempted to.
Nope.
You've never attempted to hold me in contempt.
No, sir. I'm not going to revisit all of these issues.
When I asked you where you hold me in contempt, you said civil.
Are you going to respect the decisions that I've made?
They're not
interrupting
they're
me.
not correct decisions, Your Honor.
I understand that.
I can't answer. You asked me questions. I didn't answer them based on my understanding. How can you force me to understand what you're asking me if I don't? And then you still make a finding based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not arguing with you about what you rude. I'm saying, how can you do that without my consent?
If that nice coffee liqueur I could be taking shots of. Actually, that's a pretty good idea. Get something to help me get me some energy. Hold on, I need a different alcohol.
The purpose of this court, which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other courtroom.
Okay.
Absent you, I know you've requested to be there.
I made a request the moment we walked in here to not be present for these proceedings, but yet
but you
still
also won't have a dialogue with me about your understanding
because
of what that means.
my Fifth Amendment right.
Doing shots of.
I'm exercising my rights that I reserved from the moment we walked in here this morning.
Get me some energy up here too.
You can't force that. You can't force me. You can't force me to do anything. Actually.
No, you're right, but I can make certain findings that you forfeit rights
you
have based upon your
based
conduct.
on what lawful law you're under.
I've cited the law this morning. All right, I am
Illinois versus Allen, right?
I am
that I can be present from another courtroom.
If I forfeit my right,
just got another donation.
Your Honor, I don't understand.
Language needs to be modified based upon the court's earlier ruling today.
I don't understand.
Sure you don't.
Understand the proceedings. And I think
another donation from $100 PayPal. Shot time, I guess. I understand what's going on. Just traveling through PayPal. Viably of jurisdiction acts for a shot. You sure do, sir. Thank you for your donation.
That's a violation of my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Mr. Brooks, I completely disagree with your characterization of the proceedings this morning. While it is true that you did not provide consent, you were entirely uncooperative with court this morning.
That's because I didn't understand. I'm explaining why, Your Honor. I'm not trying to leave it where it was at. I'm attempting to
answer the question.
Okay.
So I'm going to
explain myself of why I did not answer. It was because the way
Cheers,
that
guys.
you're making it seem is that I intentionally didn't want to answer, and that's
Mr.
not
Brooks,
fair.
I'm moving on to instruction 315.
Coffee.
And
Fantastic.
I still don't understand. So how can we even proceed
Mr. Brooks,
if I'm telling
do
you I don't understand?
what that I'm asking you to be
No,
quiet?
I don't. No, I
Mr.
don't.
Brooks, please stop
And
interrupting
for the
me.
record, I don't consent to being called that name,
You
Your Honor.
clearly hear me, sir, because if you didn't hear me, then you wouldn't make that statement. So
Hearing
I know
and
you can hear
understanding
me.
is two different things.
I know you can hear me, sir. I'm asking
Hearing
you
and
to
understanding
stop
is two different
interrupting me.
things. I'm not trying to interrupt you, but you're gonna at some point you're gonna ask me my opinion of what's going on, and then when I tell you I don't understand, it's gonna be taken as me trying to delay or trying
If
to do
you
this or
stop
trying to do
talking,
that.
I will explain why
Coffee
I'm bringing
liqueur
up
is best
instruction
liqueur. This is actually
315.
very
And I'm not
nice. This
gonna
Cova, I
understand
have to
your
say, it's very
Well,
nice
you
liqueur.
can't say that if you haven't heard what I have to say.
Didn't you try to do this earlier before lunch?
But I need to clarify something because 315, which is the instruction that has it's titled defendant elects not to testify. I had it in there. However, that instruction should really only be given if requested by the defendant. There's been no request made. And obviously this court made a finding that he forfeited his right to testify. And absent Mr. Brooks requesting that instruction to be in, I believe it would not be proper for this court to include 315 in the instructions to the jury. Does the state have any position on that?
Your Honor, I did look at the notes that are associated with instruction 315, and I would agree.
Mr. Brooks, do you have any position on whether this court should include instruction 315 in the jury instructions to the jury?
I don't even understand what 315 jury instruction is.
It's entitled defendant elects not to testify. I'll read it for you. It's my notes, meaning my materials, my jury instruction book says to be given only if requested by defendant, and it reads as follows. This is the actual language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. So my question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand.
The jury instruction is typically read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision though? I didn't.
My
I didn't
question
What
is,
he,
you
she
is-
just literally just told
that
you, just
you
pay
want the
attention.
jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner.
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
Because I
given
don't.
this
I
instruction.
don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I never
understand
decided
that,
either
sir.
way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to or not to testify.
I understand. I understand what you're saying, sir. I
never
really
said
do. But in light of the court's decision that you forfeited your right to testify,
How did I
do
forfeit
you
something I
want
never
the
said?
jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll ask you one more time, and if you do not answer with a yes or no, I will take your answer of not answering, as you are not making a request for a modified instruction.
How can you do that?
Do
Your
you
Honor?
want this court, sir, to instruct the jury in any way regarding you not testifying in this
I
case?
don't understand the question.
All right, then based
I don't
upon there's
understand.
not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction, or a modification as this court has suggested, 315 is to be taken out of the jury instructions.
How are all these decisions being made without me understanding?
Then I have looked over the verdict forms, and other than really what I would describe as some consistency in how phrases, whether there's all caps, not all caps, but
All caps.
what we call the sentence
Like the name that was
capitalization
on
for
there,
the
all
charges. For example, I want to be consistent with how I spell out first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized, since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to
The real drinking time is
the
every time
jury.
she
And by
says one
that, I
last
mean it's
minute.
by
Dude,
charge.
no, that's
So
not
they're
fair to me.
collated, if you will.
Dude,
So the not guilty
no, come
followed by
on.
the guilty.
Be
for counts
merciful.
1 through 76.
You said it's collated. What do that mean?
So I put the not guilty, then the guilty for count 1, followed by the not guilty and the guilty for count 2, and so on and so forth, all the way through the remainder of the counts that are alleged in this case, which in this case total 76.
I don't understand.
Uh-huh.
So how?
I looked at the special questions
Will you
that
answer
are
that, Your
on the
Honor?
guilty verdicts only. They did appear to be proper. Again, just some grammatical things, but I believe those are all accurate.
Can I
I'll
go to
turn
the other
the
court?
state-
The over-under on the
You
jury
don't have to
return.
answer any questions, but
The
I have to
over-under on
answer
the
all.
jury
Can I
return
just
is
go to the
Tuesday
other court?
afternoon.
Not at this time.
Why not? I keep telling you I don't understand these proceedings, and you just keep running right over my rights, like you don't even hear me saying anything.
Attorney Basie, are you handling the verdict forms? Go ahead.
Can I go to the other courtroom, please?
Are you waiving your right to be present in this courtroom?
I'm not waiving anything.
Then the answer is no.
I'm making a request.
Then the answer is no.
Then how's it? So what? You gonna try to force me to interrupt and do all this so you
I'm
can
not
make the
forcing you,
record
sir. I'd
and
like
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
it's you too. You're the big contributor to the whole thing.
Mr. Brooks, I have to preside over this case. I
Yeah,
have
and
to
you haven't
make
been impartial or fair
No,
yet.
God! No,
Mr.
God,
Brooks,
please,
I have a
no!
question to the state.
No!
I'm
Gotcha,
asking
bitch!
you to
No!
interrupt, and then
It's
I'll
not
give
about
a
me
response.
interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr. Brooks, I
You
will
can't force
respond
me
as
to
follows to
understand.
that. You waived your right to counsel.
I didn't waive my right to no counsel. I
You
gave you the
waived your
contract.
right.
I did not. And you won't sit here and say that for the record, because that is not
No,
what happened.
you are
No.
incorrect.
So we don't have do we have the
in your-
paperwork? Because I believe that I gave you the paperwork back that
Mr. Brooks, you
I
very
gave it to you altered
clearly
and did not waive it.
have been presenting a nuanced argument regarding
That
the
is not
right
true,
to
Your Honor.
counsel
That is not
versus
true.
the right to assistance of
That is
counsel.
not true.
That's a pretty sophisticated argument. That's why I believe you fully understand what's
I
going
don't.
on in this courtroom.
I don't fully
I
understand.
disagree with your
I
characterization
disagree with your
of the
characteristic.
right to counsel.
You know that you accepted
You
the way that I
waived
gave it to
The
you.
entirety.
So you shouldn't have did that if you had questions of me not understanding.
I don't have any questions
You
whatsoever.
definitely
sir.
do, because I'm telling you right now I don't understand, and you still won't even acknowledge the fact that I'm saying in open court on the record that I don't understand something. I haven't waived anything. You made decisions today that I didn't consent to, that I explained I did not answer because I didn't understand, which is my right to say that.
Right, Mr. Brooks,
It
you
is
are
also my Fifth
interfering
Amendment
with the
right to be
proper and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked you if you're willing to waive your right to be present. You indicated you're not.
Because
And
of
yet
the way
you continue
put it.
to
You said
interrupt.
waive. I'm not waiving anything.
Then that's why you're here until I make a finding that you, by your conduct, are forfeiting your right to be present.
Well, make the finding and kick me out. Make the finding and hold me in contempt, which is what you waiting to do anyway. That's why that courtroom is set up the way it has for the whole time, because at some point it's anticipated that I will be over there.
We're prepping based on experience. We have
which
some.
is not impartial and which is biased.
No, we're just
It's
contingency
judicial
planning.
misconduct.
Contingency planning is not showing bias. That's not how that works.
Stated from the beginning, sir, that the goals of this trial.
So you're reading from
Are
the paper, or
threefold.
are you reading, or are you just citing what
Number
you know?
one, sir, is during the evidentiary phase of this was to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process.
And I offered
That
evidence that you
includes
didn't allow.
developing relevant facts upon which a determination of guilt or innocence can be made. What is sometimes referred to in the case law as the ascertainment of truth. There's an equal but secondary purpose related to efficiency and effectiveness. That has been my repeated use of 906.11 is what that would fall under. There's a third goal of everything that I've done here, and that is the courtesy and decorum in this courtroom, what I've sometimes referred to as civility. Of course, there are other goals as well, including protecting your rights, protecting the record, protecting the jurors.
How have my rights been protected, Your Honor, if I can't even put evidence into
Disagreement
it?
with the
I can't
court
even make evidence.
decisions, sir.
Yeah, but
I'm gonna have to go back and cover where he actually threw. I'm gonna have to go back
You have not been
to
willing
where
to
he
follow the rules of
waived his right to
civility.
counsel, because we might have to go back and watch that.
Because
So
at
maybe
the
on
end,
Wednesday we'll stream that part of the trial
sir, you
so that we
If I
can
can be
revel in
present
his
from the
bad
other
decision
courtroom,
making.
I should be able to present evidence from the other courtroom as well.
Or if the
And
jury
you,
takes a
by
while,
your
we can do it
conduct
on
this morning,
Tuesday
sir,
afternoon.
you're
I'm
not
saying-
willing to
I'm saying-
answer the
I'm
most
saying
basic of
totality.
questions
The
about
totality, Your
whether
Honor. The
you
totality.
have
Have I
a
not
witness
asked?
available.
Have I not asked? In fairness, have I not asked to admit evidence? Have I not asked more than once?
Mr. Brooks, you have not asked to present any evidence.
Yes, I
in a
have.
legally
You told me we weren't at the
cognizable
evidentiary phase.
manner.
How would I know that if you didn't answer
And
answer the
you,
question?
as your own attorney, you proceed at your own peril sometimes.
That
Whether
has
you have a
nothing to
full
do with me
understanding of
presenting
the rules of
evidence.
procedure and rules of evidence or not. And
That
I
has
made that
nothing to do with me
abundantly
being able to
clear.
present evidence.
So, Mr. Brooks,
Nothing
This is your
nothing I
final
presented
warning.
has been able to be admitted into
I am
evidence.
turning to the state for discussion of the verdict forms.
Do it.
If you interrupt me or them again, then I will make a finding that you forfeited your
Make
right
the
to be
finding.
present,
Make the finding.
and you will appear from the neighboring courtroom.
You want me to appear from the neighboring courtroom?
I don't.
Just let me go.
Attorney Basie, go ahead.
Just let me go.
I felt that all the verdict forms looked good. I did ask your
This is
clerk.
ridiculous.
All right, he's interrupted. He's forfeited his right to be here. He's chosen to do that despite the warning from the court. Will be
There
in
wasn't
recess
no
until
warning.
this
I'm the one
taken
that asked.
over.
So let's let the record times. No, we don't have to be in recess. I don't agree to it.
That was fun. That was fun. Ah. It didn't sound too loud in my ear, but I don't know how it sounds to you guys, but hopefully it didn't sound too loud. I mean, the relative volumes of things when you're in StreamYard, right? It's like, yeah. Turn it down a little bit for next time. Hopefully it's better. Yeah, so no. He's going back to the other courtroom. You know, he won't waive his right. The defendant won't do it. The judge won't do it voluntarily unless he waives his right. So, but he keeps interrupting. Says like, well, eventually I'll do it by forced conduct. He thinks he's winning something. He's winning nothing. Let's see what we got here. Okay. It's not particularly helpful, but okay. Let's see. Checking just something on the bar admissions page real fast. Talk amongst yourselves. Let's see. 27 days, 270 days from when? Okay, Google, what is 270 days after April 26th? Is it really? I guess that's probably about right. All right, well, fine. Anyways, where are we? Here from Legal Vices. We welcome all the people here from Legal Vices. Glad you're here. So loud? What's so loud? Google was loud? I don't know what the volume levels are. I don't know what to do. Yeah, he has no self-awareness. I agree. Stephen C says, to be honest, I did want to see him testify. I feel gypped on the plane wreck. I understand. This op says it's crazy. You think he's walking out of here? I don't know if he thinks that or not. Can you hire an attorney for an appeal? Sure. I don't know who would take it. I don't know who would take this appeal because I don't really see any grounds of appeal that seem viable at all. I mean, I could make up shit. I could, I'd argue things, but nothing that would work, right? As an appellate attorney, like I could make arguments, but if the judge abused discretion or it wasn't competently waived or maybe something on the form, I don't know. I mean, I could make something up. It just wouldn't work. Did Brooks materially harm his case? Yes. Not that it wasn't already dead in the water, but yeah, he materially hurt it. Yeah. He punched a couple more holes in the boat as it was already sinking. Is there any point he could have delayed the trial by requesting an attorney? Probably not. No, because like the judge isn't going to let you go back and forth, So a judge can let you hire
Mr.
attorney
Brooks is
mid-trial,
now appearing from the other courtroom.
excuse me.
Appears he has headphones on. Speaking of headphones, I do need to make a correction to the record from this morning. I had made a statement that, given his demeanor, the headphones had been taken off the table by the bailiffs. I was incorrect. Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them. All right, so we are discussing the verdict forms. Go ahead, Attorney Basie, you can complete your record.
All the verdict forms look good. I did notice, I think it was actually created at this speed. For count 15, I have a not guilty verdict. I did not have a guilty verdict, but the way that it was on the paper made me believe that something happened, and I think you probably have it with your packet. It just didn't get printed off for me.
We'll make sure that that's there. Any misspellings of any names?
I did not see any.
All right. All right, I did, when we started up the video conference, Mr. Brooks has been muted. I am going to unmute him right now. And I should state again for the record, all of the verdict forms, or at least the drafts, were provided to him prior to the lunch break. So he would have had an opportunity to review them should he have chosen to do that. Do you have any position on the verdict form, sir?
I wasn't provided with anything, and if I was, I accepted and returned it for value. And since I'm now in another courtroom, are we going to address subject matter jurisdiction? You have yet to prove it for the record.
Nope.
Mr. Brooks, you were provided with the verdict forms. What you did with them, I don't know.
Again, I haven't been provided with anything.
They were provided to you prior to lunch, the lunch
I
break.
haven't been provided with anything.
Teresa, you had the large packet of verdict forms. What were they? How were they given to Mr. Brooks prior to the lunch break?
By hand to the bailiff and the bailiff to him.
And the bailiffs are confirming that the verdict forms were provided to him on his table. I will remind you once again that I do, it is my practice to put all of the not guilty verdicts on top of the guilty verdicts in a collated fashion. Again, I saw a couple of just cleaning up, I would say, not with the words themselves, but just capitalization of various words within the verdict forms, and I'll make sure that's done. The appropriate counts had and have the appropriate
Yeah, I think we'll probably review
special
this this
verdict
afternoon the way
questions.
things are going.
Those special verdict
I think we're
questions
going
are
to be
only as
done
they
here pretty
relate to
soon,
guilty
and so
verdicts
we'll review
related to
that
the use
today.
of a dangerous
We'll find it.
weapon for counts 1 through 6, the homicide counts, and then 61 through I believe 60.
It would be
Yeah.
7 through 67 have that special verdict, and then the hit and run counts have the special question related to, did each of the counts involve the death of a person, and it names the person alleged to have been killed. So those look to be all in order. I've already addressed, going back to the jury instructions 315. We have done a little bit of rearranging some of the order, but the content is there. It is my practice to read through all of the instructions up until the point of closing arguments. And then I stop. Parties are given their opportunity to argue the case to the jury. And then following that, there are what I like to call the closing instructions, or which are still quite lengthy in this case, given that they go through the verdict form specifically. And then, of course, the alternate jurors would be selected. But given,
Am I muted?
no, you're not, you haven't been.
So I got a question about the
Thank you,
hazardous use of
JoJo.
a dangerous weapon. How's that being charged? Is that under 939.632?
It is in the charging document, sir.
How's that being charged? From my understanding, that the statute reads, the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charged.
It's not an
Without
essential
being
element
a-
of the crime
Without
charged.
being, without the vehicle, there is no crime. So that
It's not
would
true. You
apply.
can commit murder without
So
a
how
dangerous
am I
weapon.
charged with?
You could beat somebody to death. It's not an essential element.
State one is
Rather-
your argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhanced
Murder with
penalty
intent does not
use of
require the use of a
weapon.
dangerous weapon, so it is not an
Well,
element
that
of the
would be all
charge.
of the intentional homicide charges and all of the first degree recklessly endangering safety charges, so counts 1 through 67.
So 1 through 67.
Correct. I can have the state respond to that.
Yeah, how is the alleged defendant?
It's not an
being
essential
charged,
element of the
So are
charge.
you asking how are you making a specific request as it relates to the special verdict question?
I would say both. Seeing as how I don't understand how, that's why there's the question.
We're very close to another
And
drink
which
from
part of
Uncivil
this-
Law.
I'm sorry, which part of the statute are you referring to again?
I believe it's 939.632.
What day of the trial was the colloquy on him waiving his
And your specific
right to
argument is
counsel?
what
That would have
again?
been first thing in the morning, one of the
How is
days.
that
Which day was it
how is
where
the
he
alleged
waived his,
defendant
where they had the
charged with that
colloquy on his
enhancement
waiving his right to counsel?
when
Does anyone know what day that was?
the statute, it says it, well, I just read it, so.
It was not day one. It was before the trial, was it? Okay,
I believe
fair
you're
enough.
referring to sub 2, which states
Yeah,
the
I guess it would
increased
have been day
penalty
one.
provided
Okay.
in this section
Pre-trial? Right.
does not apply if possessing,
Friday before the trial?
using,
Okay, what,
or threatening to use a dangerous weapon
September
is an
29th?
essential element of the crime charge.
Charge, right, that's what I just read,
all right, I'll figure it out. September 27th or 28th? Okay, thanks. You're right. It would have been before the trial. Thank you for the correction.
Well, what's the state's response?
Using, possessing, or threatening to use a dangerous weapon is not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the elements in the standard jury instructions, and the defendant can see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly charged for those two types of crimes.
That's the right answer. That's what I
Any
said.
final argument on that, sir?
Yes, that's not what the statute is clearly saying.
It is what the statute is clearly saying.
Stated, it does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge.
It's not
If
an
there's
essential
no
element of the
vehicle
crime
involved,
charged.
Where is the crime? It has to
You
be
could have committed the
essential-
murder without the use of a
part it
vehicle.
to even
You could have committed the
to
murder
even
by
be
just beating people
a
to death.
crime.
It is not an essential element.
The alleged defendant is charged with using a vehicle to commit these crimes. If there's no vehicle, where's the crime?
It's not
So
an
it
element
has
of
to
the
be an
charge.
essential element of the crime.
It's not.
Otherwise, there's no crime. I think it's the essential element. It
is not an essential element of the crime.
It's the essential element. You
Nope.
can't just walk up to some. You can't just walk up to someone and quote unquote run them over.
No, you can't run them over,
There
but
has
you
to
could
be
beat them to death.
something used in order for this alleged crime to transpire, and
Nope.
that would essentially mean
Lots of people are beaten to
The
death. More people are
quote-unquote
beaten to death than
dangerous
are
weapon.
killed with rifles.
so without the quote unquote dangerous weapon, where's the crime? So how can it be charged when it is the essential element of the crime charge?
It's not an essential element of the crime.
Well, sir, I've listened to your argument. I've read the statute. I've looked at the elements for intentional homicide and first degree recklessly endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case, the use of the vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery crime is a good example
Box
of
6 has a
when
video from 3 weeks
you
ago.
could
Thank you.
not face an enhancer for use of a dangerous weapon because
And the
you
NR
can't
$5,
have the
guys.
crime of armed robbery without the threat or use of a dangerous weapon. And
That's
so
the same argument in this, Your Honor. You can't have this alleged crime without the use of the vehicle. It's the same. It's the same thing.
it's not an essential element of either first degree intentional homicide or first degree recklessly endangering safety. So I'll
Yep.
deny the request to strike the enhancer for those reasons and find that it is properly before the jury for their determination.
Okay, 27th and 28th. Okay, fair enough,
I
Anna.
respectfully object to that, Your Honor.
Fair enough.
Understood. Do you
Thank
have
you
any
for that.
other challenges to the verdicts you'd like to raise at this time?
Yeah, would that be, will my objection to that be noted for the record?
It
Yes,
is.
no for the record.
Now I request a legal reconsideration of your ruling, Your Honor.
Denied.
May I request
Thank you for the super chat.
written finding of fact for your ruling, Your Honor?
Do I still do case
Denied.
reviews for super chats? Not right now. Bottles of whiskey, we'll talk.
Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. That was
Nice.
provided to me by the bailiffs.
May
that
I
information.
respectfully request a written judicial finding of facts and conclusion of law for this issue, Your Honor?
You may request it. The request is denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
This is not the proper court to grant such relief.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction
Your request is denied.
based on what law or fact?
Your request is not based in law or fact, sir.
I just read a statute that it came from. My argument was based on a statute.
You're wrong. You're
Oh,
wrong in your
it's
legal
not that.
interpretation. I know you're wrong. The judge knows you're wrong.
Request
The state
is
knows you're
noted.
wrong. Your interpretation is
Your
wrong.
objection to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal, noting there is no appeal that has been filed.
May I let the record show that this court will not allow the accused to adequately defend themselves in this matter?
The court's already made its findings regarding the forfeiture of right to testify and the forfeiture of the right to present additional evidence and testimony. I'm not going to
which was not
revisit the same.
Which was not consented to. I never stated that I did or did not want to
Understand.
testify.
I understand.
So how can that decision be made on my behalf when I didn't say either way? What I stated was I didn't understand the questions being answered.
Sir, do you have any other questions or issues regarding the verdict forms?
Your Honor, are you making a judicial determination that you don't have to answer any questions?
I'm not answering those questions, sir, other than how
Is that-
I've already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination by this court.
Is it a judicial determination?
Sir, I will ask you once more. Do you have any other issues?
And I will
To
tell
raise
you once more, I
with-
don't understand the questions that you are asking.
Sir, do you have any other issues to raise with respect to the verdict forms?
I do not understand the questions that you are
He
asking.
has now
I don't
twice
understand.
not answered the question. I'll ask one last time and specifically advise him that his failure to answer the question will be taken by this court as a no. Sir, do you have any
what law of
additional?
fact? Under what law of fact can you say no? When I'm
Sir,
telling
do you
I
have
don't
any
understand?
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he
I
has
don't
chosen
understand.
not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
that is
respect
incorrect.
to the
That is
verdict forms.
incorrect. That is incorrect. I stated I don't understand. You can't force me to understand something, Your Honor.
All right, did the state have any
It is-
other?
It is my
I'm
constitutional
gonna mute him
right.
momentarily.
It's
Mr.
my
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to another topic. I understand you disagree with the court's rulings, but you need to respect the rulings with proper etiquette in this courtroom, which you are demonstrating once again you're not willing to follow. So I exercised my ability to press mute. Does the state have any other
The mute button is very helpful.
requests as it relates to the jury instructions? I want to kind of full circle back to that because I do need to approve of them.
We do not.
All right, Mr. Brooks, I'll ask you the same question. I will unmute. Do you have any additional requests as it relates to the jury instructions?
Yeah, I have questions related to all of them because I don't understand any of this.
My question was not, do you have questions, but do
And
you have
my
any
answer
requests?
was, I don't understand. And I've made several requests.
The requests are not related to the jury instructions, which is the phase of this hearing that this court is attempting to conduct with you and give you the opportunity to fully participate. Mr. Brooks is choosing not to answer my questions.
You did not.
I'm going to mute him momentarily, sir. I will ask you one more time.
Thank you for the
If you
email.
have any requests as it relates to
From,
the jury instructions, I then will ask you if you approve
Amanda,
of
thank
the
you,
jury
Amanda.
instructions. If you do not answer those questions as it relates to the question, do you have any requests as it relates to jury instructions? I will interpret that as a no. And if you do not specifically answer the question about the jury instructions, I will interpret that as your approval. So first question to you is, do you have any, and you're unmuted, do you have any requests at this point as it relates to the jury instructions?
And I just said before, I said I do. I said I don't understand the questions. Of course I have questions if I don't understand.
So do you have any
That's common
requests
sense.
for any additional instructions that are
Yeah,
not included, or to remove any that are included?
Yeah, remove them all until I understand, or add the jury instructions that I have myself.
What jury instructions do you have, sir?
So now you don't know I had jury instructions, and I told you this weeks ago.
What filing are you referring to, sir? If I've overlooked that, I will certainly reconsider, but I'm not
You
aware of a
overlook
specific
you
jury
think
instruction.
It seems like you overlook a lot, Your Honor.
Can you point me to a specific filing?
So you have all my filings on file? Are you saying that you have my filings and they haven't been admitted into evidence?
Oh, my computer's not working.
Oh, now the computer's not working.
Sir, please direct me to the specific filing that you're referring to that has a request related to jury instructions.
You just said you was referring to the filings, right? Did you just say that?
That's not what I said.
Didn't you just say what filings are referring to jury instructions? Did you or did you not just say that?
I said, do you have a specific filing you can refer the court to that relates to jury instructions?
So is your computer working or is it not working?
It's being a little temperamental, but I just can't use my search function. So if you can direct me to a filing, that would be great.
It would also be great for those filings to be admitted into evidence.
Sir, simply filing something with the court does not make it evidence during the evidentiary phase of a trial. There are rules of procedure and rules of evidence that govern that.
And you told me to make all my filings in writing.
Sir, I said if you had a motion, it needed to be put in
All those
writing.
were motions. All those were motions.
Sir, what filing are you referring the court to?
Look through all my motions.
Sir, it's not my job to advocate on your behalf. If you have
I didn't
something in
ask you to advocate
particular,
on my behalf.
sir,
I asked you to do your job.
sir, if you have something, a specific request, now is the time to make it.
Well, how about this? I don't accept none of those jury instructions. I don't accept any of them. Any of them. And again, I'll tell you, I don't understand. Why do I have to keep saying this when it's clear that I don't understand?
Your Honor, I can inform the court that jury instructions were due, I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive instructions, and the defense indicated that they agreed with our filing. So I don't believe that there's ever been a request for any different jury instructions than what have been filed with the court.
So what jury instructions are you referring to, or what document is being referred to on the alleged defendant's behalf? Because as we all know, I didn't obtain the discovery in full until the end of September. So there was documents that I didn't even know that existed.
Mr. Brooks, one final time, do you have any specific requests as it relates to the jury instructions other than your request that they all be struck?
And I'm telling you, Your Honor, I don't understand the question. I can't.
All right, then I will take his response that he does not understand, that he does not have any additional requests.
I didn't say
And
that.
they will be
I said I don't
approved.
understand.
They will be approved and are,
No.
I'm gonna have to mute
No.
him. They are approved as been drafted by the court and modified during the jury instruction conference on the record this morning and this afternoon. I will once again review all of them just for grammar, just to make sure all of that is correct. And provide a written printout of the final draft for the parties before we break for the day today. I am also approving of the verdict forms that have been previously submitted to the parties, just noting there's just a few grammatical things that need to be corrected, but the content and substance are there, and I've already addressed on the record any requests by the parties this afternoon.
Mute button is best button.
That the final copy that we've been working off of is appropriate.
Any comment about that, Mr. Brooks, or any statement?
I don't consider being called that name, and I've just told you I don't understand these jury questions. I'm not going to know how they allow it to pass just because you feel that they should. When I'm telling you I don't understand them.
I would note that
One of those jury instructions came from me, not one. How's that fair?
You had the
Mr.
opportunity
Brooks,
to present your
this
instructions.
court gave
Also,
you
their standard jury
the
instructions.
draft
No, you didn't
of
give
the
me
jury
anything.
instructions.
You didn't
I
give
need
me
to mute
anything.
you because once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages
What's going on
long
here?
of the jury instructions it was considering in this case. We had a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks. It is also true that when he was previously represented by counsel, the court had some specific deadlines related to jury instruction proposals. And the state reminded me that there essentially was not an objection raised regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication forms that
Coffee
have
and
been
liqueur
sent
shots are
during
best
this
shots.
trial that are on file. I haven't seen anything that references jury instructions. I'm well aware that he has other filings, but I could not find anything related to jury instructions and any specific requests that he is making or made during this case. So for the record, I am approving of the verdicts. I am approving of the jury instructions. And once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through.
What else?
Attorney Basie, I think you brought these up prior to the break. Maybe it was Attorney Opper in terms of scheduling and what I would
Look at him
consider
take
other
the-
housekeeping
take the
issues, but
microphone.
Go ahead.
Now he
and
turns the
remind me
microphone.
once
He turns
again
the
of
turns the
issues you
headset
wanted to
off.
bring up.
Turns the headset off. What a
I
jackass!
think it was the alternate sequestration, and there might have been a third.
Yes, Your Honor. The question is to the sequestration of the jurors once they are excused for deliberations, and should the timing require that, an overnight stay or something along those lines. We wanted to discuss that. We wanted to discuss what the court intended to do with the three alternates once they have been selected. It would be our request, the position that they should remain in a secure location, separate and apart from anyone else, unless and until full deliberations are complete by the 12 selected to decide the case. So that if needed, and in light of the brief COVID history we have on this record, if needed, one of the alternates could slide into position of one of the 12 who are deliberating if that became necessary. So we wanted to address that, and then we just wanted to address timing generally for closing arguments, verdict returned by the jury, and then the court's intentions as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that.
Nope, he's good.
Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address? You are unmuted.
Yep.
I am.
I just told you, since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
No, you're
Mr.
not.
Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Well, I trust the state will object when appropriate,
Well,
if
It's gonna be
appropriate.
a whole lot of objection then, because I'm gonna tell the truth. You haven't allowed, you just been making all the decisions for me. Even though you know
Tomorrow's
I told
closing
you
statements could
repeatedly
be
that I
let,
don't
guys.
understand, and you still make
Tune in
decisions based
tomorrow, Dragon Ball
on
Z
my
on
behalf
Uncivil
without
Law
my consent,
channel
without me.
with
I'm telling you, I
closing
don't
arguments
understand,
that
and
could
you
be
still
very
make
lit with
the
Mr.
decisions
Brooks
determine
probably
my
getting
life.
shocked and dragged out of the courtroom.
Are you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy,
It ain't
civility,
no-
the rules of
don't
evidence,
try to
and
don't try to
the
come with
rules
your
of
slick
procedure?
words. Don't try to come with your slick words, and don't put words in my mouth.
Sir, I am not being slick. I'm trying to
You
preserve the integrity.
you've been slick. You've
All right.
been slick.
All right. I'm going to mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful.
I don't care.
I need to go
I don't
over
care
these.
The bailiff handed him the
I'm
instructions,
muting
just
him
threw him right
because
away.
I need to go over these important issues that have been raised.
Let
by
me
the
tell you
state.
about jury
So as
nullification.
far
Yeah,
as
Joshua,
the
that'd be real
alternates,
good.
I do think it is important to keep the alternates who in a secure location, even if that means an overnight.
Will Darryl be able to beat
lesson
Frieza?
until
Find out next
verdicts are
time
reached
on
in this
Uncivil
matter, and I
Law.
will so instruct the clerk of courts to make those
Thank you,
arrangements.
Glassbell.
We have been doing that all along. In any event, as far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their numbers, put them in the same turnstile bin that we utilized for the selection of jury preemptory strikes by lot, and to simply pull out 3 names. Those will be the alternates, and then or should say not names, the numbers, and then the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here for the appropriate time. As I indicated this morning, all of the jurors were provided with some information regarding sequestration. It is the practice of that I've approved in this case that the jurors provide us with certain emergency contact information so that we are able to get a hold of families should there be the need. They're given information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that filed in this case so that both sides know what was provided to the jurors today before they left. And then I'll also make sure that when the 12 are deliberating, that the 3 who are not are taken to a different jury room with a bailiff, and again, kept in a secure location, but separate from the other 12. In the event one would be needed, we would then take up that issue at that time. But I think it's good practice to have them available if that becomes an issue. As far as timing, I'll first address, I have instructed the jurors to be back at 9 a.m. That's because typically we have a few things to finalize in the morning. So we'll start at 8:30 tomorrow morning. It will also give the parties one final opportunity to read through the many, many pages of jury instructions and verdict forms to just make sure there aren't any other issues that jump off the page or that need to be addressed first thing tomorrow morning. But then I do intend to start with instructing the jury. This case will require a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read, with perhaps a longer break at the lunch hour. And my best guess is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now,
5 to 6 hours. Oof.
pages, though, are after argument. And so that really kind of begs the question.
Okay, that makes a little bit more
is,
sense.
Will the parties get to their closing arguments tomorrow, or will that be done Wednesday morning? I certainly would like to have the parties make their arguments. Yeah, clerk, can I see the instructions that we have thus far? The packet? I just,
It should be done.
okay, thank you.
Single side.
So the instructions that I read prior to the parties giving their closing arguments finishes on page 73. So
Yeah.
given that, I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us, whether the final instructions are given the following morning. Because that's another 30 pages. I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late, but letting the jurors go to the hotel and then starting their deliberations in the morning if that's what needs to be done.
Understood, and we'll be ready. I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which was 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half to read those remaining 30 pages. And we may still be able to wrap up by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury, and to highlight the important points.
Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying book. I'm looking at the Bible. Thank you.
The Bible's a kind of book.
Not just a book. It's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it though? Anyway.
Sir, I'm contemplating.
I'm not sure which section of the Bible you think
contemplates.
contemplates to your actions, incidentally. How many people actually live by it? I'm not sure.
Will most likely be tomorrow.
That's
Given-
sure.
Then you'll forfeit your right to give one, sir, because as we have.
You can't force me. You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How's that lawful
Sir,
law?
if you choose not to give one,
How's that lawful law?
sir, if you choose not to give one you're not letting me finish and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
You didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead. Make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think.
He's not going to
deal
give an
with
hour.
what is
He's
read
not going to give a
prior to
closing. He's not going to make it. He's not going to make it 10
That
minutes.
means the
We'll
parties
be done tomorrow.
should be
We'll be done
prepared
tomorrow.
to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be
$5
prepared
says,
to go
please make this
tomorrow
make sense.
afternoon.
I got
Then
nothing.
the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. You know, if it's 7 o'clock at night, I'll probably tell them we're going to break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That'll be Wednesday morning. But now that I really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow.
Yeah.
And so that's
Yeah.
my expectation.
We're going to get this
So,
done tomorrow.
Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure, it is my
Okay.
job to make sure there's effective and efficient administration of this trial.
So
You are-
then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth, that they have the power. They have the power to nullify laws. They don't agree
You
with
are
it.
absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise. And you can't, so you added in jury instructions at the last minute, then you should have never approved them from the get-go, because I never approved them. I told you I didn't understand them at all whatsoever. And you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me
Man, I
you've
don't
done your
care what
homework.
you're talking about. I don't care what you're talking about. I'm gonna let them know that they can nullify any law they don't agree with, which is my right.
It is not your
Now,
right
say
to do
it's
that.
not. Say it's not.
It is
Show me
not
where
your
it's at.
right to raise
Show
jury
me.
nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here. And
That's
I
definitely
will
gonna
be
happen.
able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow.
Oh, I know. I muted
rulings
myself
that
during that
I
commentator. I
make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented. And those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will very he will be in that other courtroom for his closing argument so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concerned themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to cover the verdicts, and that this jury will take some time due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I'm contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But I think some of it will depend on is it late at night? Is it during the day? Are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well. Even if I consider kind of, the outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that. Any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating, if you intended to maintain the designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, with the
The
reserve.
entire side behind the state for victims.
Okay, and the other side
Public.
reserved for the first 5 minutes, or is that open seating over there? Or do you
My
wanna think
previous or my rule throughout has been 15 minutes. What I would say is any open seating will open the courtroom. It'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side.
Okay.
If that's what you're asking me.
Yes.
All right. Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
So, again, I don't understand nothing you just said, but, I don't, how can you deprive me of my constitutional right? How can you trample on my constitutional right?
She explained it several times.
How?
Sir, you can forfeit a number of constitutional rights by
Ah.
misconduct on your part.
Not if I reserve my rights, you can't let me reserve my rights and then take them from me.
Sir, I
Yes, you
direct your
can.
attention to Chambers versus Mississippi,
I'm not
Rock
gonna hear
versus
none of that.
Arkansas, State
Yeah.
versus Anthony, Illinois
did they
versus
reserve their
Allen,
Did they reserve their rights?
the
Did
Beneby
any of those
decision. There's a host
Did
of
they-
case
did they-
law, sir.
Did they reserve their rights?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We are in recess.
Oh, I'm sorry, I have a few
Go ahead.
other. I'm
You
sorry.
do. I'm
Yes.
sorry, go ahead.
I just wanted the record to reflect that at about 2:04 PM, your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions. Another
Did that
thing,
include the verdicts or just the jury
No,
instructions?
just the jury instructions, I'm still doing verdicts.
Okay, it's just the jury instructions, but thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that.
were all jurors or will all jurors then be told to report with an overnight bake?
That's part of the instructions that
Okay,
they were
and you're
given.
gonna make that available to us?
Yes,
Okay.
I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken back to the cell. I see your arms waving, I'll get you in a second, that he's provided with that as well,
All right.
and you as well.
And then one final thing as to timing, and again, I don't mean to be disrespectful to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire week set aside yet. And I
So we
have
might get
Monday
sentencing
morning,
this
but
week.
I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing.
You're gonna have time this
I
week.
would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members? I
Yes,
don't think I need a PSI. This is a trial. This is not like a guilty plea. So, Mr. Brooks, I'll get you. I'm unmuting you. Go ahead.
Yes, go ahead.
You're unmuted.
And since we're all making records to make you look bad, I think we should state for the record that one of the rights I have is to demand that the court place in the evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says you
right
have a
under the-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
Sir, that is very general, your statement. It's vague. There's nothing
So we gonna go
specific
what?
you have
What
referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making
So,
general arguments
also-
that aren't based in fact
Yeah.
and are overgeneralizations of what the law requires as well.
I accept for value in return for value any documents in this matter. Since, it might be another record of what I'm doing, since it's always a record of what I'm doing.
She has to make a record, or it would be
And
very
I
helpful
also
at least to
have the
make a
right-
record. She has to make a record.
I also have the right to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the flag,
Oh,
it's some explaining that needs to be done. And that is a military symbol.
hey,
So, is
he got
it a common
there.
law court or admiralty law?
Hey, he got
Brooks, I'm
there.
frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
All right, that's good shit, ma'am. I'm just gonna stay here for just a second, see if anything else happens before see if they cut the feed. Lol. Lol. Closing's gonna be wild, guys. Tomorrow's gonna be fun. We'll be streaming tomorrow for sure. Tomorrow's gonna be fun. Will he get tased? There's that gold fringe flag that we saw. God bless the United States of America. Lol. Okay. I guess that concludes our day from that. That's fun and exciting. Lol. All right. So someone sent me the link for the thing on the 28th. So let me see where that link went to. Let's see. All right, so let's see this thing.
Something to the effect that it was their opinion that Mr. Brooks reasonably understood with reasonable accuracy why the evaluators were there, the limitations of the confidentiality associated with that even during times during those evaluations, if he was being difficult, that he was nonetheless able to communicate with them. He was articulate. His remarks were coherent, fluid. At times, though, they were avoidant of questions asked. I would say this, my observations of Mr. Brooks and perception over the course of the proceedings throughout this case is strikingly similar to some of the commentary and observations by the evaluators, including even the angry outbursts that we've seen in court, the avoidance in his responses to questions asked.
I object to
That
that because
his,
at the end of
I
the day,
understand, Mr.
I
Brooks,
object.
stop. You can
I
object. Your objection is noted. I'm going on. This is one of the expectations that I have, is you can object. It will be noted, but you can't keep interrupting.
Yeah.
I need to have an accurate record.
Okay.
So
you're
your
reading from
objection,
something-
sir, your
You're
objection
reading
is
from something
noted.
that I haven't been
This
privileged to
is a
read
prime
myself.
example of some of the difficulty with Mr. Brooks.
I don't think you have a PhD,
He
Your Honor.
can be, in my opinion, deliberately disruptive, but nonetheless, he maintains being competent at the most basic level in order to present a defense on his behalf.
Object to that.
Now, I talked earlier about some of the case law, or at least referenced it, and I want to start with that, or I should say, start my decision, my ultimate decision at this point with the case law. The Sixth Amendment guarantees a mentally competent defendant the right to represent himself in a criminal trial, no matter how foolish that choice may seem. This is a quote from Beretta versus California, found at 422 U.S. 806. The quote is from Imani versus Pollard, and the court in that case went on to say the following: the constitutional right, quote, exists to affirm the dignity and autonomy of the accused and to allow the presentation of what may, at least occasionally, be the accused's best possible defense. That's Imani versus Pollard, quoting the McCaskill case. A judge may not deny a competent defendant's timely invocation of his right. Under Ferretta, a defendant's reason for choosing to represent himself is immaterial. Defending pro se will almost always be foolish, but the defendant has the right to make that choice for better or for worse.
Pro per.
In
It's the same
Wisconsin,
thing.
just like in Ferretta, the court recognizes his right to represent himself. What this court needs to determine is whether Mr. Brooks is making a decision um, competently, freely, voluntarily, what we refer to in the case law as a knowing and voluntary waiver. That is why the court went through the advisement of the charges, the penalties that Mr. Brooks faces, why it gave Mr. Brooks form CR 226, and went through that with all of the advisements here today. That's also why the court went through the advantages of having an attorney and the disadvantages and challenges of being one's own attorney and representing oneself. I believe that the record demonstrates this court has warned Mr. Brooks about what he is getting into, the challenges, or at least some of the challenges that he may face, including on topics such as jury selection, trial objections, rules of procedure, etc. In the words of Imani versus Pollard, what this court needs to do is make sure the defendant makes the choice with eyes wide open. And that's quoting Iowa versus Tovar. I have made Mr. Brooks aware of the dangers and disadvantages of self-representation by going through not only this form, but by reviewing with him once again the charges, the penalties, the exposure that he faces. Ultimately, in the end, a competent defendant has a constitutional right to represent himself, even if the judge or anyone else thinks there may be no good reason for him to do so. I'm not saying you don't have a reason, sir. I'm frankly speaking to your mom at this point. She may not understand. Frankly, her understanding is not material. You have the constitutional right to make this choice. What's important for this court, and why I also went through some of the other biographical information, is you have a high school education. You've completed the 11th grade. You have an HSED. You are clearly literate. You've been able to communicate with the court efficiently and effectively. At times, you press the court when there is something you don't understand or believe is not going your way. But to me, that's a sign that you understand and are advocating on your behalf. Frankly, statements like "I'm informed" or "I'm aware" are the functional equivalent of you saying "I understand." I cannot say that this is one of those narrow class of Mr. Brooks.
I object, which is my First Amendment right to be able to say what I want.
Mr. Brooks, your rights do not involve interrupting me. That's the,
I objected. I didn't
that's
interrupt.
the
I
procedure
interjected.
that we will
Object.
follow. At trial, what's going to happen if you
His mom wrote a
continue to
letter
do
saying he
that,
shouldn't be allowed to
you will
waive
be
counsel. That's funny.
admonished in front of the jury
That's fine.
if you continue that.
That's fine.
Like I said, this is not one of the narrow class of cases in which a defendant may not be competent to represent himself, because there's no evidence before the court to suggest he has a severe mental illness, which is why, of course, I looked at the NGI evaluations, because that is competent, recent information
That has
before
no
this
relevancy.
court regarding his mental status
It has no
and his
relevancy.
understanding of what is going on.
That has no relevancy to
This
why we're
court
here
has been
today.
able to render the following. It is this court's opinion in finding today that Mr. Brooks understands with reasonable accuracy and is aware of the difficulties and disadvantages of self-representation, the seriousness of the charges against him, as well as the general range of penalties, and that he is making a deliberate choice today to waive his right to an attorney and proceed without counsel. This court further finds that Mr. Brooks is competent to proceed, whether he refers to that pro per, pro se, or simply self-represented. He reads He writes, he understands the English language, he's been able to communicate with the court. He has no physical or psychological disability that impacts his ability to communicate with the court or to communicate a defense to the jury on his behalf. I've not been able to find on the record, and he has not advised the court of any disability, physical or psychological or otherwise, that would affect his ability to communicate with the court or to a jury. In the words of Pickens, Mr. Brooks has the minimal competence necessary to conduct his own defense. I'll further find that he understands the proceedings, the nature and seriousness of the charge, the maximum penalties that can be imposed if convicted of these offenses. He understands that a lawyer may be of assistance, understands that a lawyer may be
Formed,
appointed if the
I never
defendant
said I
is
understand.
indigent, and understands the disadvantages of
Never once said
self-representation.
I understand.
He is voluntarily and freely waiving the
As a
right
matter
to
of
be
fact, I do not
represented by
understand.
counsel and is making a deliberate choice to proceed without counsel. And therefore, the court will grant the motion to withdraw brought by Attorney Perry and Attorney Keyes. And from this point forward, Mr. Brooks will proceed as his own attorney. Does the Public Defender's Office require any type of written order discharging?
No,
All right, the minutes on CCAP will be sufficient.
yeah, that's fine.
All right, if there is the need, just simply file an order under the local rule, and I'll certainly review it and sign if appropriate.
Thank you.
Anything else you need from me today before I continue with this hearing?
From
No,
us,
from Attorney Perry and Attorney Keyes.
from us, no.
All right, you may, you are discharged and certainly are excused from the remainder of this hearing.
Your Honor, can I just clarify, as to the discovery, Attorney Perry, you indicated all paper discovery had been turned over, but not the electronic discovery, correct?
Not turned over, but it will be, we'll make arrangements with the jail.
You're gonna turn over the electronic discovery? Yeah. Okay. Very good. Thank you.
All right, I
Yep,
know we
they're gonna
have
give
a
him all
number
this
of
stuff.
outstanding issues. That documentation was provided to Mr. Brooks at
Goodbye.
the close of the hearing yesterday. Mr. Brooks, are you in a position to respond to that so that the court can address those outstanding issues today?
What are the outstanding issues?
Those are the documents that I gave you yesterday.
The ones that I already had?
I don't know whether you had them or not, but I specifically gave you all of the pleadings that had been filed from the motion to withdraw forward. That was provided to you yesterday.
So what are the issues?
Are you prepared to address them today, sir?
What
You
are-
have two options, sir. We either address them right now, or I have to come back yet before the trial or decide all of them on the morning of trial, and I'd rather not do that.
That might be the way to go, because I don't know what issues you're referring to.
So you didn't read any of the paperwork that I gave you?
I think, Your Honor, that you should understand my position in the jail, that I'm not awarded adequate time out of my cell to get a lot of things done. There are a lot of things that
Well, that's enough of that, I think. Well, fun and exciting for the whole family. Wow. 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 When he goes to prison, I'm going to be so happy. It looks like we're going to do sentencing this week too, which is also a nice bonus. So yeah, they need about 2.5 hours to read through the forms in the morning. Okay. And there's going to be argument. State will give its argument. Darryl Brooks will get up and rant. The judge will, have a fight with him. He may get zapped. Say that the argument's over. State will probably not use its rebuttal time. And then the jury will be given another 30 pages. So that will take about another hour or so, hour half. So we're looking at 4 hours plus about an hour maybe for all that shenanigans. So we're looking at about 5 hours tomorrow plus breaks. So yeah, I think the jury gets this. Jury gets this mid-afternoon, and they can fill out the verdict forms fast enough. They can be done that evening. So I think there's a very good chance we're going to be done tomorrow evening. If the jury turns in the jury says we're done at 5 or something, it's like, and they call everyone back. Maybe they read the verdict late. So the court might go to 6 or 7, right? Because they're going to ask the jury, do you want to dismiss for a day? The jury probably says no. Finishes up. So we might get the verdict late tomorrow. But I think that's most realistic. And if not, then we get it before lunch tomorrow or lunch the next day. So, yeah. No way the jury wants to sit there and debate guilt. Yeah. Okay, so a couple people asked me about jury nullification. So I'll talk about that for a little while. So jury nullification is the idea that the jury has the right to find all the facts and decide that the person's not guilty anyway. So it goes to the role of the jury, right? The role of the jury is to find all the facts. Just to find the facts. So that their role is to find the facts. And beyond that, their role is dictated. So if, it's basically a logic tree. If you don't find one of the facts, then not guilty. If you find all the facts, then guilty, right? So the jury determines the predicate, and then the result follows as a compelled, right? So jury nullification is the idea that the jury can say guilty, but also say not guilty. It's the idea that they can say, yes, we find all the facts beyond a reasonable doubt, but we're saying not guilty because, for example, we disagree with the law itself. We don't agree with the law. So we're going to find that yes, all the things are true, but still not guilty. So yeah, you can't. So that's the idea, right? And so juries have this power, but not the right, according to relevant court proceedings, right? Because a jury can lie, and there's nothing stopping them from lying. A jury can simply say, yeah, we didn't find all the facts, even if they really did. Because, you don't inquire, and there's nothing you can punish them with, and you can't put the defendant back on trial again, so double jeopardy, right? So, the jury can think in their own heart, yeah, we found everything, but tell the court we didn't find everything, right? So they have this power. What Darryl Brooks wants to do is he wants to tell the jury about this, right? So this is just a logical truism that the jury can do this because it's just a logical truism of our system. The jury is the finder of the fact, and the jury can lie. The jury can say we didn't find all the facts, even if they did, right? But we're not going to tell the jury they can lie, right? We're going to tell the jury they have to tell the truth, and hopefully they follow that instruction, right? So arguing jury nullification is arguing basically in so many words that you, the jury, have the right to lie. You have the right to decide the law itself, whether or not the law itself is just, which incidentally doesn't really make any sense here because of course it is, but still, nevertheless, right? So the reason he can't argue it is because it's not a legally cognizable defense. It's the same reason a defense lawyer can't argue it. A defense lawyer can make any legally cognizable defense, right? So there are defenses that are legally appropriate, like I didn't do it, I wasn't there, I didn't have the right mental state, I was compelled or forced in some way, I was under duress, or whatever, right? So there are legally cognizable defenses. I was insane, right? So you can argue any legally cognizable defense, any defense that's supported by law, and anything that the facts would allow for. So, like, you can argue I didn't do it, it wasn't me, I wasn't there, I wasn't in my right mind, I was being forced, double jeopardy, right? Those are some of the legally cognizable defenses. So a defense lawyer can't get up and say, hey, jury, have you thought about, just not obeying the court's instructions? Right? Because no, right? The jury has to follow the court's instructions. Now, strictly speaking, I suppose they don't have to because they can always not. We're not going to tell them that, right? So you can't argue it because it's not legally cognizable. It's not an argument that is legally valid because of course it's not. So like, yeah. And Thor says more like what jury would nullify in his favor. Excellent question. I don't know. But that's what he wants the ability to argue. And the court's like, no. Because, the court, the jury is more likely to nullify the other way. Not that, if the jury had any reasonable doubt, the jury could, of course, lie the other way, but there's mechanisms to deal with lies the other way. Like a jury could theoretically say in their own minds, like he's not guilty, but return a verdict guilty. Which is one of the reasons, for example, we have the ability of the judge to set aside a verdict, right? The judge can set aside a guilty verdict, not a not guilty verdict, right? You can only do this, it's a one-way valve, right? Because there's no double jeopardy. So if a jury comes back with not guilty, there's jack shit the judge can do. If the jury comes back with guilty, the judge can say, nah, right? And that's pretty rare, but it does occasionally happen, more likely on appeal than a trial judge, but it does occasionally happen, right? Because the judge is like, look, I don't know what's wrong with you guys. This is clearly beyond, there's clearly reasonable doubt here. So although all 12 of you said guilty, I get to step in and say, nah, and so there is a relief valve the other way around, and the Court of Appeals can do that. The trial judge does it, right? So if a jury nullifies the other way by saying guilty when they really think not guilty, or guilty because whatever, right? We have mechanisms to deal with that. We don't have mechanisms to deal with it the other way because of double jeopardy. So anyways, yeah. So that's all that good shit. Yeah. Maybe nullify to allow for vigilante justice, maybe. Yeah, maybe the jury nullifies because they really want to be taken care of on the streets. Maybe, but yeah. My worry is there's a soft sit in the jury. I wouldn't worry about it too much. I think it's exceptionally unlikely. Soft sits are pretty far and few between. I wouldn't worry about it too much. A fuzzy creature says, what happens if he does argue nullification? What's the recourse? Does she just close? Yeah, pretty much. There's a special jury instruction about it. As she said, like, because it's not the first time the courts have heard it, there's a special instruction for it. Basically being, the instruction basically being in so many words, you just heard some bullshit. Yeah, ignore that bullshit. You have to follow my instructions. I know that jackass said you don't, but you do. So, go do your jobs like you were sworn to do. So yeah, I think if he argues nullification, he's going to be shut down. His entire closings, I think, going to be shut down. So I don't think we're going to make it very far tomorrow. I don't think we're going to make it very far because I figure I think the over under on tomorrow is about 60 seconds, to be quite honest. That's basically, I think the over under 60 seconds. Do we make it 60 seconds without, basically all going to hell? And I think the odds are probably no. So yeah. Soft sits would be very, very unlikely to make it through the jury process because they're very, very unlikely to show up. And even if they did show up, they would be expressing their disdain that the court doesn't have power over them anyway the whole time, right? What soft sit would show up in response to a subpoena, in response to a jury subpoena, and then not like spend every second saying this court doesn't have power over me because I don't recognize this court's authority because gold fringe flag and shit. What soft sit is going to make it through a jury panel selection, right? So I wouldn't really worry about it too much. There's some soft sit there. And also, like, you wouldn't know that this is the case that, like, to be on because that soft sits shit, yeah. Wouldn't argue it, risk the jury hating him more? Quite possibly. Yes. Yeah. Will jury ever be able to sit down? Yeah, I don't know. So that's what it is. I'm being generous with 60 seconds. Yeah. Yeah. So I wouldn't worry about it too much. I think our over under tomorrow is about 60 seconds. It's like, let me tell you, members of the jury, you have power to decide whether or not to do this. It's like, and he won't even do it. Like, as a lawyer, you can allude to it, right? You can allude to it without saying it, if you're clever enough, right? You can you have to have the jury read between the lines. But if you're a lawyer and you really want to argue jury nullification, you can do it. You just have to be a little bit clever about it, so that so that what you're saying is technically ambiguous, but everyone knows what you're really saying, but it's technically ambiguous, and be like, oh, what was I saying at all? Just pointing out the jury has the power to decide, the facts, and all the rest of it. So you can push it a little bit, but of course, he is nowhere near sophisticated enough to be able to make anything like that kind of an argument. So he's not clever enough to do that. Don't worry about it. Yeah, he's not clever enough. Don't worry about it. Can a jury come back too fast? Not really. Is there a minimum amount of time they're expected to take since there's so many charges? Not really. Right? If there's no deliberation, there's no deliberation. Right? If they're all good, because they've been there the entire term, they've heard everything. Right? So they've all been thinking about this. Of course they have. I mean, they didn't shut their brain off. So there's a minimum amount of time? No, not really. And is the Court of Appeals going to care in this case? No, not in this case. Is there some case in which a jury could come back too fast? Yeah, I suppose it's possible. Like if the evidence is really thin, or there's other sorts of indicia of like problems, then like a jury coming back really, really fast might be a piece of a puzzle along with other indicia. But there's nothing else here, right? Every juror going back and saying, and someone just saying, so like, are we all good? And all the jurors being like, yep. Anyone have a problem with us filling out the forms? Nope. Okay, you guys want to split it up or something so we can fill it out faster? Sure. So like a jury doing that, like, yeah, there's no, it was too fast. If the jury has nothing to discuss, they have nothing to discuss. If they all go in and be like, yeah, we're good, great, end of deliberation. So yeah. And sometimes juries know the verdict but hang out to make it look good. That too. Sometimes juries just hang out for a little while because like, oh, we want to look like we were muzzling it over or whatever. But yeah, so all good. Yeah. Will court appoint Brooks a lawyer for appeal? I honestly, if he wants one, I'm pretty sure yes, because he has one appeal as a matter of right. And so if he wants one, yes, they would appoint someone from the public defender's office, which would be a really challenging appeal. I'd come up with something. It wouldn't be any good. But sometimes as a lawyer, you're doomed. Like, I can only do so much, right? I'm not God. I mean, I can come up with arguments that like, I come up with arguments that, yeah, but no. Yeah. Duncan says, what do you think of the movie The Verdict? Is it realistic and correct way to mention jury nullification? It's been a long time since I've seen The Verdict, so I don't know, but yeah. Will he get a public defender for sentencing? No, not that it matters anyway. No, he won't get a public defender for sentencing. That's part of the trial phase. And like, I guess your appeal could argue excessive sentencing, but like, how long has the trial been going on? Not that long, I think. It's only been going on for like 2 weeks or something, maybe less. Is that 60 seconds from when the judge says you may start, or 60 seconds from when it actually starts? We'll say 60 seconds from when he actually starts. 60 seconds from when he actually starts talking. Yeah. Do you feel there's any burning of buildings because Brooks found guilty? No, I doubt it severely. He says so very, very guilty. Yeah. So like, if I was forced to write an appeal for him, like I would, try to argue that like he didn't really understand, I guess, his waiver of his rights based on the form. I guess I could try to argue that he didn't really understand his waiver. Um, he didn't really effectively waive his right to counsel. I guess I could try that. Um, um, maybe something from the jury selection process. It's not a long list, guys. I'm trying to reach really deep into my deepest part of my brain and struggling to see what can I pull out of this. Um, I guess try to say all the times he didn't understand and like basically argue it at face value. Um, it's not going great over here on Uncivil Law land. I'd like to think that I'm good at appeals, or good at appellate law, but I'm not God. I can't do everything. Aware versus understand. Yeah, I don't know. Yeah, I don't know. I don't really have any hope for appeal. I'll find something to write about for 30 pages, but I'm gonna need a big stiff drink when I submit it because I'm like, it's like, but yeah, he altered the waiver form. Yeah, that's basically something like that. I could try to argue that something like that, but nothing's gonna work. How big is my hat? Well, I'm not sure how big 95 is. It's 8 3/8 um, in American hat sizes. So I'm not sure what 8 3/8 means in terms of like centimeters and stuff. Uh, let's see if there's a way to convert hat sizes. Convert hat sizes. Let's see. Hat sizing chart. Convert hat sizes. Let's see. Okay, I need to go from adult size. No. Is it inches? No. Hold on. Hat size conversion chart. This chart doesn't go up high enough. Let's see. Nope, not big enough. Nope, not big enough. Nope, not big enough. Um, well, it's bigger than 65 centimeters, if that helps. Yeah. Did the state prove intentional homicide? They made their prima facie case. I'd vote guilty. I'd vote guilty. They made their prima facie case. Would I build a box for it? Maybe. Big head, big hat, big head. Other things that are big. I also have a size 12, wear a size 12 shoe. So you can use that information to your imagination. Giga chat, maybe. Show feet to prove it. Lol. Ring size? I don't know. I'd have to find my ring. It's been a while since I got measured. Your husband has a size 13 shoe? Nice. Oh, there was another. We did cross the next $100 mark in super chats. I'm sorry, I neglected. We did pass the next $100 mark, so I owe you guys another shot. For me to you guys, uncivil law to me, to you guys. It's been a lot of fun. Cheers. Eight and 3/4. It's 8 3/8, not 8 3/4. 8 3/8. Brian, those lights up, brother. My lights. My lights are bright. Let's see what we got. We could do. Is that better? A little brighter. Cheers. Does the judge allow Darryl to give a closing statement? She's going to try, but he's going to forfeit it. Do I have a discount code for Stream Deck? No, not yet. I just got it myself. I've been following the Whitmer trial, not really super closely, no. Didn't they come back not guilty in that? How many shots am I at? I had some earlier, and I think I'm 3 deep this afternoon. And I think I had 3 or 4 earlier today. Closing arguments for Whitmer tomorrow? Okay. I thought that was over for some reason. You liked my Texas bar law chat? Appreciate that. Thank you. Ethan Crumbly pled guilty. That's interesting. I wonder why. I mean, they wouldn't offer him anything, so I'm not sure why he pled, but okay. What I think his strategy is, he doesn't have one. He said the gun was unsecure. How could the prosecution go for closing 45 minutes or less? Because they got it. They got it. Think Brooks will use his closing to say whatever he planned to say on the stand without having to deal with cross-examination? You're not allowed to do that. I'm sure the judge will prevent him from doing that. All right, I'm going to sign off for now. Have I ever seen things as egregious? No. I'm going to sign off for now. If you've been enjoying this chat, please remember to do all the YouTube things. First, may I ask you to briefly consult with the subscribe button and see if it is indeed still gray. It might have been gray before, but perhaps it's become angry again. If it is red, please remember to click it so you can subscribe. Hit the like button on your way out, and did you know for a mere 99 cents, you too can become an uncivilian? It's true. All you have to do is hit the join button or the link that the bot tells you about from time to time, or the link in the description of the video. Any of these options will be great, and you can join as an uncivilian for 99 cents a month, and higher tiers are now available if you want to do that as well. We will see you guys tomorrow. I've been Uncivil Law. Till later, my friends. I hope all is well. Cheers, my friends, and goodbye.